designs or copyright. Many businesses will possesses highly confidential. Some businesses are highly confidential. Confidential means secret. Information, designs, trademarks, and copyrights which are protected as intellectual property under intellectual under the Copyright Design and Patents Act 1988 and the Patent Act 1977. The legislation protects the employer's intellectual property from being misused or abused by employer or other third parties. Misuse or abuse the talent of a person. Quite often, an employer will also regulate the position further in the context of employment, particularly for senior employees. By mean, sometimes senior employees can copy the intellectual level of their employees. There's a problem in intellectual property law. So the intellectual property law should protect our talents. Then scope. What is the scope of intellectual copyrights? The division of tangible property categorized as either movable or immovable dates back to Roman times. We have two types of property, tangible and intangible. Now, part of modern civic codes, intellectual property resulted from rapid development during the Industrial Revolution, which drastically advanced the fields of technology, science, culture, and property rights, such as copyrights, patent, and industrial designs. The three pillars of intellectual property rights: copyrights, patent, and designs. Legally, intellectual property is a type of law meant to protect one's creation of the mind. Creation of the mind is very important word. Creations of the mind. IP laws protect the invention, the form of said invention, and the relationship between a business and a symbol. Symbol means the by example, there are two mobiles. One is Sony Ericsson and one is Samsung. The design is completely different. These are totally square shape, Sony Ericsson, and the Samsung mobile. The point of square is something circle. Totally different design. These are the different between the two products design. So as a technology progresses at a rapid pace, we can expect IP laws to become stricter in future. To summarize, intellectual property is a concept characterized by pieces of information that may be incorporated into tangible objects anywhere in the world. The scope of intellectual property rights covers trademarks, patent, literary works, artistic works, trade names, designs, models, neighboring rights. Neighboring rights is something which is neighboring. Just I clarify what is neighboring. What is neighboring rights? Actually, neighboring rights means a public performance royalties due to the sound recording copyrights holder. It is related in music industry. Every song has two basic types of copyrights attached to it. One for the composition of the song and one for the recording of the song. The composition copyright pays the songwriters and publishers, while the sound recording copyright pays the artist, that recorded the song and record label. The performance right refers to the right to publicly broadcast the music composition associated with a given song. The neighboring right is the payment due to the owner of the sound recording for the same public performance. Payment for payment for neighboring rights are called the neighboring copyright system. Now let's talk career opportunity in IP. There are varieties of opportunity in IP law. First is competition law. Second, audits and uh, valuation, corporate law, investigation and enforcement advisor, fashion, media and sports, litigation, patent lawyer, patent analyst, licensing specialist, PLPOs, legal process, outsourcing, and 11 is patent LPOs, legal process outsourcing. So here is a competition law. Um, if intellectual property is known to monopolize a create or invention, competition law is known to stave off monopoly. The TRIPS agreement. TRIPS agreement, the full form of TRIPS agreement is Agreement on Trade Related Aspects of Intellectual Property Rights. That is means TRIPS agreement provides the scope of enforcement of competition law vis-a-vis anti-competitive licensing practices and situations. Therefore, uh, through a thorough analysis of strategy, company policy, and the development of new policies along with drafting contracts is an emerging opportunity for IP lawyers. Then audits and valuation. Intellectual property auditing is a tool primarily used to take into account the intangible assets which the companies have developed over a period of time. IP auditing and valuation is very important because it accounts for the goodwill of the company, and is one of the many reasons why the companies acquire protection. It is important to identify intellectual property that is owned, used, and acquired by a company for managing risks, troubleshooting issues, and implementing best practices in IP asset management. And the company usually needs an IP lawyer to perform all the aforementioned activities. Corporate law is very known in India too. In the field of intellectual property, contracts, agreements are very important legal aspects. We all know. So, which type of drafting we need in corporate law? Generally, confidential information agreements, license agreements, assignments agreements, franchises agreements, inter alia. Therefore, an enterprising lawyer must be familiar with the problems associated with IP, problem associated with IP and its associated agreements. Then, investigation and enforcement advisory. What is this? One of the key areas of IP enforcement is the detection of IP rights being violated. In such cases, the investigators who have proper knowledges of laws relating to intellectual property can conduct inquiries and deliver appropriate direction on whether to take any action or not. And one of the interesting Source of IP is fashion, media, and sports. There are the niches area of practice where intellectual property law plays a central role. Why? This sector are why this sector are IP this sector are IP intensive. In addition to registering patent, copyright, and trademarks, these industries have substantial amount of work relating to licensing, franchising. We are all know we need franchise. We can hold the franchise in fashion, media, assignments of IP prosecution, as well as enforcement of IP rights worldwide. Because fashion, media, and sports are all are worldwide, not in only for our country. Litigation, a very important area. Litigation is just a crucial field. An individual just has to take the time to work hard and make their name known in the field of practice in judiciary, in court. Then another important place is patent lawyer. There can be several jobs a lawyer having specific knowledges of patent law can do. Some of them are like patent analysis. Some of this patent analysis, the role of patent analyst is to look up the potential patent applications. They may also work for a company that develops to product, evaluates the proposed product, and decides whether it can be patent or not. They are work for patent analyst. Then licensing specialist. What is licensing specialist? Licensing specialist typically work for government agencies. They are responsible for providing licenses and permits to applicants while complying with the rules and regulations of the company. It is the matter of totally license. Amongst others, their duties include the following: collecting and verifying identifications files, reviewing and validating requirements, answering inquiries, collecting fees, etc. Then patent LPOs, or legal process outsourcing. The role of a major LPO service provider includes several features such as legal documentation and writing legal reports. Whose role it is? Legal processes outsourcing, legal memo development, document management, litigation support, and data entry. Patent search application, drafting, trademark and copyright registration, legal research, and analysis of intelligence service are other highly skilled LPO tasks. A patent drafting specialist, one of the important place in IP. Patent specification is a highly technical legal document and has two purposes there. What are the two purposes? To disclose an invention to the public, to disclose the invention to the public in a language that will enable the public to work the invention when relevant patent rights have expired. Number two, to identify the subject matter that the patent application or patent owner intends to claim exclusively for themselves. Another important and secure job is government job in intellectual property. What is the education qualification as a government job seeker in an IP? Candidates can enroll in the, sorry?
5 ವರ್ಷ ಆದ್ಮೇಲೆ ಎಲ್ಲ ಸಬ್ಜೆಕ್ಟ್ ಪಾಸ್ ಆಗುತ್ತೆ. He is there, Salvataya.
May I continue?
Yes, madam. Yes, madam.
Sure, ma'am.
Continue, please.
So government job in intellectual property is education qualification is very important. Candidates can enroll in the following educational course to obtain career prospects in the intellectual property in government field. Postgraduate diploma in intellectual property rights and patent management. Postgraduate certificate in intellectual property law and practice, certificate course in intellectual property rights and information technology, postgraduate diploma. Sorry, I just shared the is help. Um, just wait, please. Yes, that is a government job in intellectual property. A postgraduate diploma in intellectual property right law. Some of the government organizations that recently recruited candidates for the field of intellectual property law were program manager intellectual property law. Which type of company? Biotechnology industry research assistant program. Technical member intellectual property affiliated board. Average pay scale, it is very important. Average, just compare the pay scale. As a IP lawyer, this all income are per annum. Legal associates, this one, and IP lawyer, the black one is IP lawyers income per annum. Then career opportunities of intellectual property studies in abroad. So patent and trademark attorney average salary 1,45,000 per year, $1,45,000 per year. So patent and trademark attorney means the job of the patent and trademark attorney means around IP management and protection. They are required to draft and submit applications seeking patent, who seek patent and the trademarks for their clients, and assist in matters related to IP disputes such as copyright infringement. They have an advisor or representative role towards their clients. Work such as evaluation request, drafting, filing, handling applications, and the registration process comes under their portfolio. They earn an average $1,45,000 per year. The next role is in abroad. In abroad, the next role is support roles. Support roles means it's very easy. I don't say the work is very easy, but the meaning is very easy. In a law firm, the team doesn't consist of only attorneys, but also entails numerous high-profile support roles. For example, patent records team leader, temporary patent secretary, senior trademark administrator, patent examiner, etc. Their average salary generally 1 lakh pound per year. Then IP solicitor. To become a solicitor, you need a minimum of 3 to 5 years post-qualification experience. A solicitor's job entails prepare legal documentation, same as a lawyer, representing and or defending a client's legal interest. In this case, the solicitor needs to be a qualified legal practitioner whose expertise is in IP law. Their income 85,000 pound in UK. Why it is pound? Because solicitor you can study solicitor only in UK, not in America. In entire world, only solicitorship is you can study in UK. So the the income, the earn also in pound, 85,000 pound. Setting up your own law firm, solicitor and barrister, you can only study in UK. Setting up your own law firm. We all know working in an IPL law firm is very different from being one. Nothing beats being your own boss, in your law firm. You can generate good revenue from your own practice. You can expand your practice however you want. IP creates and supports high paying job. If you open your own IPR firm, you will be helping people gain employment. It is important for you to identify your needs before you go about running your own law firm. Find which is also most interesting and appearing area of interest for you within intellectual property rights and income, along with dollar, a law firm revenue potentially $210,000 per year. Next is litigation. Litigation is an evergreen field, we know, of law. Common types of IP litigation are mainly patent litigation, copyright litigation, trademark litigation, and for trade secret litigation. The average pay for litigation associates is $123,897 per year. Then is paralegal. It is very interesting area, paralegal. Paralegal, you can earn a salary ranging from 13 to 40,000 dollar per sorry 13 to 40 dollar per day. It is online on site, of course, and like Upwork and Fiverr, depending on your skill and expertise. Paralegal in the USA earn $51,000 annually. What is paralegal? Paralegal assist attorneys. Paralegal actually assist attorneys with the legal representation of the firm's clients. In a firm specialization in IP law, a paralegal who is an expert in the same field of law would be required. The work would entail conducting trademark and prior art searching, preparing application, drafting appeals, listening important evidence, preparing first draft of license agreement, production agreement, royalty sharing agreement, IP agreements, drafting a patent landscape report, drafting a filing a pre-publication objection to a trademark registration application, etc. Then freelancer. It is very known word, freelancer. You can sit in a comfort of your home and earn money by making profiles on sites such as Upwork and Fiverr. These are all freelancing sites, Upwork and Fiverr. Simply list your academic qualifications, certifications, and experience here, and you can opt for freelance work such as drafting an IP contract agreement, proofreading, content writing, patent assistance, etc. The pay will differ on the basis of your assigned and opt for. Then another interesting is teaching. An ideal candidate to pay be a IP professor needs to have expertise in patent, trademark, or copyright law, or have experience in all three fields. There are both lateral level and entry level jobs available. The former requires a superior publication record, while the latter needs the candidates to showcase a commitment to scholarship. The candidate must have a doctorate to qualify for the position. The income, the income of USA is 1,75,000, and in UK their income is 75 pound, not year, that is monthly. 75 pound is monthly. Oh, no, sorry. I'm very sorry. 75 pounds is yearly, not monthly, is yearly. Then is career opportunities of IP studies in the United Kingdom. Now, United Kingdom, types of patent attorney. Types of patent attorney. Areas of expertise include biotechnology, chemistry, pharmaceuticals, electronics, engineering. Responsibilities, very because here is responsibilities is a main key point. Tasks vary to the certain extent depending on whether you are working in private practice, advising private clients, or working for a large organization in industry to protect their invention. However, you will typically need to carry out invention harvesting as part of group, discuss invention and process with inventors or manufacturers, and ascertain whether they are likely to success in being granted patent. Analyzing power. Analyze scientific or technical documents. Write detailed technical description of invention in precise legal terms. Suggest modification or extension to the definition of the invention. Apply for patent from the Intellectual Property Office, that called IPO, and the European Patent Office, EPO. Prepare responses to report from patent examiners. Ensure application and renewal deadline are met. Advise client on how much their patent could be worth. Work with solicitors and barristers to defend or enforce UK patent. Conduct litigation in processing at the EPO or the Intellectual Property Enterprise Court. Intellectual Property Enterprise Court. And salary. Now is salary. As a trainee patent attorney in UK, you can earn in the region of 27 pound to 36 pound per year. 36,000, so 27,000 pound to 36,000 pound per year. As a newly qualified character patent attorney or European patent attorney, your salary can be 61,000 pound to 72,000 pound. And your salary, and if you are qualified as both CPA and EPA, then your salary could be 68,000 pound and 79,000 pound. CPA and EPA with up to 4 years experience can earn between 68,000 pound and 96,000 pound, rising to it 87,000 pound plus alter 5 years. At partner, director, or head of the patent level, you could earn in excess of 98,000 pound. Salary also vary depending on the on a range of factors such as your experience, area of expertise, type of employment, etc. And additional benefits include bonus, the payment of membership subscriptions, health care, life insurance, and a pension. Uh, then working hours. Working hours usually Monday to Friday, and they celebrate very much weekend in Saturday to Sunday. But the working hours is very crucial. Generally, it is started from 9 a.m. to 5 p.m. And expectation. What is the expectation? Work is usually office-based, although you may need to visit clients who wish to patent a product or process that is easier to demonstrate on site. You may also have to visit court, the IPO and the EPO, European Patent Office, EPO means. You will need to be comfortable working to tight deadline and dealing with several different patent applications for more than one client at the same time, or managing a portfolio of inventions in-house. Jobs are available throughout the UK. This is a relatively small profession with over 2,000 patent attorney in the UK. In UK now 2,000 patent attorney here. There are excellent career prospects, but getting into the profession as a new trainee can be competitive. Now, qualification. You will usually need a degree at least 2:1. 2:1 means first class, but here is 2:2 also granted in a science, engineering, technical or mathematics based subject to get a job as a trainee patent attorney. Training largely takes place on the job and includes self-directed study, in-house support and guidance, and external training course. There are many training courses on IP in UK. There are two parts of the qualification process, and you must successfully complete both in order to be accepted on the UK Register of Patent Attorney, held by the Intellectual Property Regulation Board. The UK qualification route you take will probably depend on your employer's preference and is divided into two levels: foundation and final. At foundation level, you can complete either the IPR Accreditation Foundation Certificate Examination provided by the Patent Examination Board. This is a system of UK. And IPR Accredited Postgraduate Intellectual Property Certificate course. Then skill. Skill is very important because our CV is boosted by skill. So you will need to have an understanding of scientific and technological principles and processes in order to understand the invention. How is the invention? What is the invention yourself, and be able to explain it to others. So you need to read properly. So communication skills, particularly written skills, in order to convince the IPO that a patent should be granted. Analytical and problem-solving skills, the ability to express complex technical ideas clearly and concisely. Attention to detail. Interpersonal skills for dealing with clients, the ability to structure structure a precise, coherent agreement, confidence and tenacity, a willingness to get to grips with legal and commercial arguments, and analytical and vocacy skills, self motivation, that is very important, self motivation, and the ability to manage your own workload, time management skills, a readiness to take responsibility, teamworking skills, and a collaborative approach to work, and understanding of the commercial requirements of patent attorney work. Next is work experience. Getting that is employers, but one is important. I just want to discuss work experience. Getting relevant work experience with patent firms is challenging due to the confidential nature of the work. It is very neat. It is very important. That is confidential nature. Although opportunities are rare, Easter and summer internship lasting 1 to 2 weeks to exist. This internship will give you the opportunity to find out more about the role. Now is employer. How is employer? Patent attorneys are typically employed by specialist law firm in private practice, the law, intellectual property departments of large industrial companies, in-house or corporate position. In-house jobs are less common. However, the most patent attorneys work in private practice. Although the core skill you need for both jobs are more or less the same, and the job themselves can be very different. For example, if you work in private practice, you will often focus on customer service, meeting deadlines, and business development. However, in industrial in-house role, you more likely to be involved in managing a portfolio, decision making, and networking internally. Also, when working in a private practice, you will be working for a range of clients represented by the law firm, while in industry, you will have the one employer and will need to make decisions based on the needs of the company as a whole. Now, the last one is now another important is career prospect. What is the career prospect? Once qualified, the usual route in the private practice is to gain experience before going on to become a partner of a firm. There may be an intermediary associate step before partnership in some firms. You may decide to specialize in a certain area of patent, such as chemical patent, or choose to spend time helping the firm expand and develop. However, you will still be expected to make a significant contribution towards patent work too. And professional development. How can we professionally develop our patent knowledge? Attending seminars and webinars on particular areas of patent work and intellectual property law run by CIPA and other relevant organizations, and attending seminars to help develop your business skill when running a practice, teaching work, examine and tutoring. I think I can little clear about patent. It is one of the difficult theory. So and you need to actual patent means you need to practice. Then you need to read. Hello, sir.
Yes, madam. Yes, madam. We are hearing you.
Yes.
Tell me.
Yeah, I just completed my slides. So
Okay. So
I don't know
my any
actually.
yes. No, you really did your part, and we really thankful for your kind deliberations. And I request the audience, you have any query regarding with the intellectual property rights, please do ask. Audience ನಲ್ಲಿ ಯಾರಾದ್ರೂ ಪ್ರಶ್ನೆ ಕೇಳೋದಿದ್ರೆ ಕೇಳಿ. So I suggest all the audience, particularly the law fraternity, that so here is the specialist on IPR. Sir, Advocate Dharanish want to ask a question to you, madam. Please, sir. Please, sir.
Good evening, madam.
Good evening. Yes.
My name is Dharanish. I am from Bangalore, working as an advocate. Basically, I am a mechanical engineer working in the field of HVAC industry, heating, ventilation, air conditioning. And recently, I completed law degree also as a circumstantially. And incidentally, IPR is my subject and interest also. Elective subject in my law.
Yes. Yes. Yes.
So I have a work experience of almost 19-20 years in the HVAC industry, mechanical industry, basically. HVAC,
Yes.
like heating, ventilation, air conditioning, is quite big. And I worked in Target stores, US and Saudi Arabia and Dubai also. So I was just, I'm very grateful to you showing the light on many opportunities of IPR. I require your help, madam. Can you suggest me?
I suggest if you want in abroad,
Yeah.
I should suggest follow all websites.
Okay.
I just I don't I just forgot I share a link in this PPT
Okay.
for IP, and
Okay.
also you can take help in Indeed and as well as the link India. Okay.
It would be grateful if you could kindly provide your email or WhatsApp so that
I
I can be.
suggest which I can. I
Yeah.
also I always search in Google. Okay, Google is
Okay.
my master.
Okay. It would be great if you could share your presentation also to Purushottam sir so that it will be of some help.
Sorry.
Presentation PPT to Purushottam sir.
PPT is already
Yes.
PPT is already shared, sir. PPT is already shared in the group.
Thank you so much for organizing this kind of a seminar, sir, for your
Thank you,
grateful
sir.
effort.
Sir, my point is,
Please, sir. Your voice is breaking. You are not audible, sir.
our law
No.
should not only focus upon the conventional practice, they
Yeah.
should look upon the special practices as well. As such, I would
Mm.
like to tell everyone that in India, 80% of the lawyers or 80% lawyers are into the litigations, and particularly the conventional part of
Yes.
litigation, civil and criminal cases.
Yeah.
And 20% of the people who are into this corporate litigation, which includes the IP sector. Whereas 20% of the litigators who are particularly corporate sectors and the IP sectors, they are making a money of the 80% population, 80% litigators who are in India, who are in the conventional practice. So that is where
Yes.
we see differently in US and UK, where US and UK, where only 20% of the lawyers who are into the litigation and 80% who are into this corporate litigation, which includes the IP sector. So that is the funda where we are all lacking financially, and the lawyers are coming across the financial difficulty because of all practicing this conventional law practice and suffering. So if
Absolutely.
we get out of that suffering, we need to focus upon the other areas, which is required, and especially the IP sector, and presently the trademark infringement passing of cases, copyright registrations, patent registrations, and all. And
Yes.
particularly in India and particularly in Karnataka, there is one organization, the Karnataka State Science and Technology Department, which is the organ of the Ministry of Information and Communication Technology, which is based at Indian Institute of Science. So where they are incubating the all the engineering local engineering universities, engineering colleges,
Hmm.
and they are promoting this IP services, and they are giving IP protection for the engineering graduates who are into this invention process.
Yes.
Hence I thank Madam
Yes,
for
yes, it's
her
very important. It's
wonderful
very important.
deliberations.
And I just include another is we are very dependent in litigation. The another way is arbitration. It is
Yes,
very
madam. Yes,
important.
madam.
It is very important to introduce arbitration in our legal system. Because it don't need huge time, which litigation needs.
Yes, madam. Yes, madam.
Yes, ma'am.
Litigation, see, IP litigation has its own future presently, and I request the law students to focus upon this IP litigation, and I request them at least after graduation from the law, they have to practice 3 years. Thereafter, they can choose the IP sector as their core practice, core legal practice, where they can economically improve
Yes,
themselves.
yes, yes, of course. Because IP is in our salt too, salt, everyday salt.
Yes, yes, madam. And particularly the traditional knowledge, that is also one of the intellectual property rights, traditional knowledge rights. So, as I was a LLM graduate from the National Law School of India, University, Bangalore, I
I
was
see.
into this traditional knowledge, protecting the traditional knowledge of the of the medical, particularly the domestic medical healers. So Nati Vaidyas, they are said called as Nati Vaidyas. So
Mhm.
when I was working where I was found that most of their intellectual formulas which was arrived of, for the medical formulations that are being commercialized by the pharmaceutical companies, and they are not sharing their benefits also. So where their rights are being infringed, and I got a very good professor by name Professor Ramakrishna T. So he's a chairperson of the CIPRA, Center for Intellectual Property Rights at National Law School, Bangalore. So he had a very immense knowledge on IPR, and he has emphasized regarding with IPR studies and its significance across the globe. Hence, today's deliberation definitely throw a light upon this area, and I really thank one and all for joining the program. Thank you very much, madam.
Thank you, madam.
Any
Thank you
questions?
too.
Any questions? Idra keli. Zaya madam, questions keli.
Yes, good evening, ma'am.
Yes, good evening. Look.
I am also practicing advocate here in Karnataka. And madam, I have one questions then. Because one person resided in abroad and one person is in India. And suppose one person who is in abroad has infringed the right of this patent and copyright, whatever it may be that. So where he can sue the violations of infringement of this copyright and this patent. Could you say
Yes,
about
yes.
this thing, ma'am?
Is there is is Singapore, London, France.
Yes, suppose if you could take this kind of the examples, then please explain me that, because we know the such an idea and such a knowledge in this field, because as a sir told that we practicing in the criminal and civil side, but it might be included this intellectual property, and we have this one subject where when we are we studied in college, but we have known such an idea and such a knowledge, because such a kinds of cases didn't we face and deal. So the when such issues arise that, So what would be your suggestions in this regard?
Yes, yes. Actually, it is the same matter as a jurisdiction matter. Okay, and
Yes.
so you need to know the particular country. India is okay, but the another country is where. Now we need to grab the what is the jurisdiction of London, France,
Mm.
and I just forgot. The,
India.
yes.
India.
So you need to grab first the jurisdiction.
Okay,
Okay.
ma'am. Because you just to think that, madam, that transaction, that patent which they have made violation, infringed, and that patent to the persons who is residing in India, and that persons who has got that right and that patent right, who has he is a proprietor of that patent, and
Yes.
from that person, so the person who has in abroad and he has infringed that. So the sitting in abroad when he has violated it is one. So the person who is aggrieved by this one, and where he can sue for that, whether the person who resided there, where they in London and France, as we told that, or where here in India, the person here in this place only. So what about that? There is an option is there, or any particular the jurisdictions has prescribed in either country and as well as that in our in the Indian.
Sorry, just cut your voice. Just in a last line. In last line, I can't listen.
Ma'am, just I'm telling that because so the sitting where the person in abroad, then he has infringed the rights of the patent. The person of the person who is in India, he is the owner of that patent, and the person of the Indian, whether he can sue that person of
Yes,
who has infringed
she
that
or
in
he
India,
can.
or
He
where
or
that.
she.
But whatever law that in England, that UK, where you are there, so what is law is there? How it can say that? Of course, that the according to Indian law, that the person can sue here only. But
Yes.
the law of that your country that says that where it is whether that is applicable to that one, or and the person who is actually the owner of that patent, and he can sue there only, which country he is belonged.
Madam, can I
Actually,
add a point here, madam, with your permission?
yes, yes, of course. Why not?
Yeah, just to answer our query, see, patent law is internationally common. Nowadays, with that agreement signed, I don't remember exactly which agreement. So, international law
Which
sitting
agreement?
here, if somebody has infringed in UK, he can sue sitting here. Madam, I suppose I answered your query.
Madam,
Sitting
there is
here.
No, sir, you are true
Sitting
that.
here means
I know that.
you mean
Please
Yes,
continue,
yes,
ma'am.
you mean
that
India?
is our query. What is the law to sue a person sitting there who has infringed? It is an internationally accepted common law, patent law for all the countries in the world. So
Yes.
international patent law is common. So patent applies to world over.
Okay,
So
so
that's
you
what
are
I would
saying
like to
that
add.
the intellectual property is a common law. It applicables to all the countries, including the India, and there is
Yes,
no
yes,
any changes in the law of in the intellectual property, and it's
correct.
applicable.
But
But I
there
don't
is
think that
after Brexit there is a little change in UK.
okay.
Before Brexit, European Union is added, so you can suit in France. But if the matter is only UK, if the matter is only
Mhm.
UK,
Okay,
then
there are
you
little
should
changes.
suit the file in UK's
Okay,
IPO.
Otherwise, more than
That is
90% of
situated
it is
in
common.
London.
More than 90% of it is common.
Yes, sir. Yes, sir.
Okay, thank you.
Ma'am, could you could you one thing clear me then? So as you told that in UK that there is a law that the person who is in UK and then he has infringed the rights of the persons of the Indian, and the person the Indian person can choose his jurisdictions to sue that of in India and as well as in UK. So it is true that suppose that the Indian person has violated and was infringed the rights of patent of the person who is in England, and the England that UK person can sue there only against the Indian person. But you know that whether the Indian law, as you told that some little changes were there, whether the Indian law is required to apply there to deal such a cases, or whether the UK laws is used to be there to deal this kind of the cases.
then it is totally a madam international matter. So there is the ICA.
Yes, ma'am. IPA.
Yes.
Uh, okay, ma'am. Okay, IPA, it means that it's a common to all. So there is not a lot of changes in the law.
No, no,
As
no, 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 no. Actual, there is a ancestral model law in international commerce. Sorry, not arbitration. Sorry, it is in the time of infringement. If the person is in UK and India,
yes, ma'am.
that is the matter of ICA jurisdiction.
Oh, right, right. ICL, ma'am. So is ICL, I think this common law is there, isn't it, ma'am? It's common law
Sorry,
is there. ICL, it's applicable to all the countries, isn't it?
sorry.
So ICL, there is a common law is there. So it applicable to all the countries, isn't it?
Yes, according to TRIPS agreement, it should follow the all the countries entire the world.
Okay, ma'am. So suppose the whatever the ICL given the verdicts, suppose and that is not the agreed by any persons, is there any remedy to go the above that that jurisdiction, that authority? Is there any such an hierarchy is there in this regard?
It's not clear. It's not clear. Please clear
Ma'am,
it.
I'm telling that. So you told that the ICL is the authority that this kind of the issues applying the common law.
Hmm?
And I'm telling that the person who is agreed the order and verdict of and judgment of this ICL, is there any higher authority above this ICL, or whether this is a final authority to giving the verdicts and judgments that we are the binding for that one. So how it is
No,
that?
ma'am. No, ma'am. Try to understand. Every international law maintain the local jurisdiction's custom.
Yes.
Okay. So
Yes.
if infringement between India and UK, there
Yes.
there is a balance. There you need to balance. Actual,
Yes.
but this is the matter of IP. There is no custom. There is a in the IP law is not a there is not a national section or articles. It's entirely international articles. So you breach the international contract always. If you breach you breach the international contract or agreement,
Mhm.
because
Yes.
you
Yes. Right.
this is not our domestic violence case or other criminal case. It is the IP matter. It is totally an international law. And
Right.
India also signed it. India also signed it in TRIPS agreement, because India
Of
maintained
course.
TRIPS agreement.
Yes. Yes. Right, ma'am. Right. And thank you, ma'am. Thank you for
So
giving the.
thank you, madam. Thank you. It was a wonderful question posed by the Zaya madam, who is a distinguished advocate in Karnataka. So is this one more question from Narayan Swami R, who was Redmi Note 9 Pro. You have any questions, sir?
Yes, sir. Yes, sir. Audible,
Yeah,
madam.
question.
Madam, any opportunity for the Indian lawyers directly working for the in remote work and on-site work in abroad works give me any opportunities, ma'am?
Sorry, I can't hear properly actually.
His question is there any opportunity for Indian lawyers to work in the abroad, and particularly in UK, having a law
In
degree in India?
yes, ma'am. Any remote work or
Actually,
will
sir, actually, I honestly tell you that if you have any UK's degree, it is very easy to apply in UK's firm or company. It is not. It is fact. Actually, it is fact, because I every day watch it. I every day watch it. If you have any UK degree, it is easier, more easier,
okay.
because our IITs, IIM are very reputed. in abroad, but our law colleges are not very reputed. I
Okay, ma'am.
don't
Okay.
know. I don't know why, but basically I support national law colleges because they are identically very better, very much better, much better. Okay, but if you have, honestly, I say, if you have any UK degree or America degree, then it is better for you.
Ma'am, any on-site or remote work possible, madam, in for
Onshore,
freelance
onshore or offshore opportunities.
on-site or
On-site, madam.
remote working opportunities for
Remote working. So you can
on-site or
approach
remote working.
legal process outsourcing, no, madam. Legal process outsourcing.
Hello.
Yes, madam.
Hello.
Yes, madam.
Yes.
Any
I am studying in Indian law degree. I am qualified for the on-site or remote working for the eligible for the other working, ma'am. Any opportunities
Narayan Swami sir,
in
madam will
Upwork and
you.
Fiverr, ma'am?
Voice is going breaking.
Hello.
Yes, it's very breaking. For that reason, I can't understand.
Okay, madam. So thank you very much, madam.
Hello.
Thank you very much for your deliberation. Narayan Swami ಅವರೇ, ನಿಮ್ದು ಪ್ರಶ್ನೆ ನಮ್ಗೆ ಅರ್ಥ ಆಯ್ತು. ಇಂಡಿಯಾದಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಅವ್ರಿಗೆ ಏನಾದ್ರು ಆಪರ್ಚುನಿಟಿ ಇದೆಯಾ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ಆದಂತ ಗ್ಲೋಬಲ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ಸ್ ಇರುತ್ತೆ. ಆ ಗ್ಲೋಬಲ್ ಸ್ಟ್ಯಾಂಡರ್ಡ್ಸ್ ಮೀಟ್ ಆಗ್ಬೇಕು. ಸೊ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು UK ಡಿಗ್ರಿ ಇರ್ಬೇಕು ಅಂತ ಹೇಳಿ. ದೇರ್ ಇಸ್ ಒನ್ ಮೋರ್ ಆಪರ್ಚುನಿಟಿ, ಲೀಗಲ್ ಪ್ರೋಸೆಸ್ ಔಟ್ಸೋರ್ಸಿಂಗ್ ಅಂತ ಇದೆ. ಸೊ LPO ಕಂಪನಿಯಲ್ಲಿ ನೀವು ಕೂತ್ಕೊಂಡು ಫಾರಿನ್ ಅಲ್ಲಿ as a paralegal volunteer you can work to the IP analyst and IP attorneys. ಅದನ್ನ ಮಾಡ್ಬೋದು. ನನ್ನ ಮೇಡಮ್ ಅವ್ರದ್ದು ನಂಬರ್ ಇದೆ, ನಾನು ನಂಬರ್ ಕಳಿಸ್ಕೊಡ್ತೀನಿ, ನಂಬರ್ ಶೇರ್ ಮಾಡ್ತೀನಿ. ಸೊ ಅವ್ರ ಜೊತೆ ಯು ಕ್ಯಾನ್ ಇಂಟ್ರಾಕ್ಟ್ ಡೈರೆಕ್ಟ್ಲಿ. ಓಕೆ, ಸೊ ಐ ಥ್ಯಾಂಕ್ ಯು ಫಾರ್ ಶೋಯಿಂಗ್.
PPT ನಂಗೆ ಕಳಿಸ್ಬಿಡಿ ಸರ್. ಸೊ
PPT ಆಲ್ರೆಡಿ ಶೇರ್ ಮಾಡ್ತೀನಿ.
ಥ್ಯಾಂಕ್ ಯು.
Please mute yourself, sir.
Okay,
Swagata madam. So I really thankful and we are all very grateful for your service, madam. To
No,
this
sir.
group.
No, sir. Thank you. Thank you very much.
So thank you
very much
so
to give me
for
this
your,
opportunity.
for
Thank
your
you.
service, madam. Thank you so much, madam. We will get back to you, madam. Thank you very much.
Thank you.
Thank you so much, madam.
For your nice presentation.
And good night to all my friends.
Jai Shri Ram. Thank you so much, madam. So ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳನ್ನ ತಿಳಿಸ್ತಾ ಇದ್ದೀವಿ. ನಮಸ್ಕಾರ.